In this presentation, I'm going to be looking at the facts of the case in order to determine the various strengths of Stephanie's claim. Furthermore, I would also be speaking on the need for the court to adopt a new thought of intentional infliction of emotional distress. Now, when looking at the facts of the incident, it is clear to see that Stephanie has a strong claim for intentional indirect infliction of harm. As a result, the rule in Wilkerson versus Downtown would be applicable in this scenario. First of all, we need to look at the actions of the defendant. According to the original rule in Wilkerson versus Downtown, D is liable in tort if he conveys information to C, knowing that information to be untrue, and as a result of believing the information to be true, C suffers injury or harm. Now, in order to prevail in a unique claim for intentional infliction of emotional distress, the plaintiff must prove awareness of a special sensitivity well understood by the defendant and either intended by that defendant to cause psychological harm or with reckless disregard as to its hazards. I believe that Stephanie's case has all the components of an intentional infliction of emotional distress case. Now, in the situation between Ahmed and Stephanie, Ahmed had made a premeditated decision to inform Stephanie about the untrue news that led to her resulting panic attack, which then resulted in her waking up in an ambulance. Now, the action of telling her about the fake news can be classed as an outrageous conduct, and the obvious fact that the decision was premeditated would suggest that Ahmed did in fact have an intention to cause emotional distress, or that he had recklessly disregarded the probability of causing emotional distress. And furthermore, there was no justification or reasonable excuse for Ahmed telling Stephanie this fake news about Michael getting into an accident. I do believe that Stephanie's case is further strengthened by the fact that her and Ahmed had been in a relationship, as this may suggest that Ahmed possessed the requisite intent. Stephanie has revealed that her and Ahmed were in a 6-month relationship until she met his friend, Michael. I feel like any individual that was in Ahmed's position may have felt some sense of betrayal from both, and as a result, this joke may have been an attempt to get back at both parties. Legal precedent is also in favor of Stephanie, as this incident is very similar to the case of Janvier versus Sweeney, in which an individual had told a woman that he was a police detective and that she was wanted for communicating with a German spy. He had done this in order to obtain certain information about her employer. The woman suffered shock and nervous illness as a result of this statement. The court had held that the defendant was liable for the nervous shock to the plaintiff. As a result, when taking legal precedent into consideration, I believe that Stephanie has a good claim for damages for emotional distress. I also believe that she has a claim for fraudulent representation, as Ahmed was fully aware that the news about Michael was untrue. And although he had known this, he has still gone ahead to tell Stephanie about this. Now, however, in order for cases such as Stephanie's to be decided effectively, I believe that a call for a new thought of intentional infliction of emotional distress is necessary. Historically, it has proved difficult to differentiate casual, friendly teasing from deliberate verbal arrows or bullets aimed at the most vulnerable area of the mind and soul of another. As this thought began to be recognized, some academics have often denoted it as a catch-all, utilized when no other claim encompasses an act for which a plaintiff deserves financial compensation from a given defendant. Even today, though reports and testimonies of clinical and forensic psychologists have been accepted as evidence in major court cases, psychology continues to be viewed as a soft science to most people. Hence, the acceptance of the thought of intentional infliction of emotional distress evolved by cautious degrees. In addition, there is hardly any evidence that can be shown in the case of intentional infliction of emotional distress. There are no witnesses that can be called upon to testify, as most of the incidents occur in the privacy of the parties. Furthermore, there is also criticism that it is based too much on the personal opinions of the judges, and members of the jury. Adding to all this, the fact that the standards required for an action to be called intentional infliction of emotional distress seem too narrow, and the cause of action itself seems to be defeating the purpose to which it was trying to achieve in the first place, which was to provide compensation to people against whom emotional distress has been inflicted with intention to hurt them. As a result, I do believe that the courts should adopt a new thought of intentional infliction of emotional distress. Thank you very much.